Welcome to Stalkers Identified, where we turn victims into victors. Today in Stalkers Identified, we're going to take a look at the stalking laws in the state of Colorado. So let's get right to it. Stalking in the state of Colorado under 18-3-601, formerly 18-9-111-4 Legislative Declaration. The General Assembly hereby finds and declares that stalking is a serious problem in this state and nationwide. Although stalking often involves a person or persons who have had an intimate relationship with one another, it also can involve persons who have little or no past relationship. A stalker will often maintain strong, unshakable, and irrational emotional feelings for his or her victim, and may likewise believe that the victim either returns these feelings or affection or will do so if the stalker is persistent enough. Further, the stalker often maintains this belief, despite a trivial or non-existent basis for it, and despite rejection, lack of reciprocation, efforts to restrict or avoid the stalker, and or other facts that conflict with this belief. A stalker may also develop jealousy and animosity for persons who are in relationships with the victim, including family members, employers, and co-workers and friends, perceiving them as obstacles or as threats to the stalker's own relationship with the victim. Because stalking involves highly inappropriate intensity, persistence, and possessiveness, it entails great unpredictability and creates great stress for the fear for the victim. Stalking involves severe intrusions on the victim's personal privacy and anonymity, with an immediate and long-lasting impact on quality of life, as well as risks to security and safety of the victim and persons close to the victim, even in the absence of expressed threats of physical harm. The General Assembly hereby recognizes the seriousness posed by stalking and adopts the provisions of this Part 6 with the goal of encouraging and authorizing effective intervention before stalking can escalate into behavior that has even more serious consequences. CRS 18-3-602 Stalking Penalty Definitions. Vonnie's Law. A person commits stalking if directly or indirectly through another person, the person knowingly makes a credible threat to another person and in connection with the threat repeatedly follows, approaches, contacts, or places under surveillance that person. A member of that person's immediate family or someone with whom that person has or has had a continuing relationship, or makes a credible threat to another person, and in connection with the threat repeatedly makes any form of communication with that person. A member of that person's immediate family or someone with whom that person has or has had a continuing relationship, regardless of whether a conversation ensues, or repeatedly follows, approaches, contacts, places under surveillance, or makes any form of communication with another person. A member of that person's immediate family or someone with whom that person has or has had a continuing relationship in a manner that would cause a reasonable person to suffer serious emotional distress, and thus cause that person, a member of that person's immediate family, or someone with whom that person has or has had a continuing relationship, to suffer severe emotional distress. For purpose of this paragraph, a victim need not show that he or she received professional treatment or counseling to show that he or she suffered serious emotional distress. For the purposes of this Part 6, conduct in connection with a credible threat means acts or further advance, promote, or to have a continuity of purpose and may occur before, during, or after the credible threat. Credible threat means a threat, physical action, or repeated conduct that would cause a reasonable person to fear for the person's safety or the safety of his or her immediate family, or of someone with whom the person has or has had a continuing relationship. The person need not be directly expressed, or the threat need not be directly expressed, if the totality of the conduct would cause a reasonable person such fear. Immediate family includes the person's spouse and the person's parent, grandparent, sibling, or child. Repeated or repeatedly means on more than one occasion. A person who commits stalking commits a Class 5 felony for a first offense except as otherwise provided in subsection 5 of this subsection. Or B commits a Class 4 felony for a second or subsequent offense if the offense occurs within 7 years after the date of a prior offense for which the person was convicted. Stalking is an extraordinary risk crime that is subject to the modified presumption sentencing range specified in Section 18-1-3-401-10. If at the time of the offense there was a temporary or permanent protection order, injunction, or condition of bond, probation, or parole, or any other court order in effect against the person prohibiting the behavior described in this section, the person commits a Class 4 felony. Nothing in this section shall be construed to alter or diminish the inherent authority of the court to enforce its orders through civil or criminal contempt proceedings. However, before a criminal contempt proceeding is heard before the court, notice of the proceedings shall be provided to the district attorney for the judicial district of the court where the proceedings are to be heard, and the district attorney for the judicial district in which the alleged act of criminal contempt occurred. The district attorney for either district shall be allowed to appear and argue for the imposition of contempt sanctions. 7. A peace officer shall have the duty to respond as soon as reasonably possible to a report of stalking and to cooperate with the alleged victim in investigating the report. When a person is arrested for an alleged violation of this section, the fixing of bail for the crime of stalking shall be done in accordance with Section 16-4-103 2D. CRS and the protection order shall issue in accordance with Section 18-1-1005 or 1001 5. This subsection 8 shall be known and may be cited as Bonnie's Law when a violation under this section is committed in connection with a violation of a court order, including but not limited to any protection order or any order that sets forth the conditions of bond, any sentences imposed pursuant to this section or pursuant to sections 18-6, 803.5, or any sentence imposed in a contempt proceeding for violation of the court order shall be served consecutively and not concurrently. So once again, you can see that stalking in the state of Colorado is a criminal act backed up by felony convictions and jail time. At Stalkers Identified, we take stalking very seriously. And if we can be of any assistance to you in locating and identifying for the purposes of identifying this person so that you can then have them arrested, convicted, we will prepare everything that we can in order to assist you with that. in locating this person or persons who is stalking you or your family. Thanks again, and if we can be of any assistance, Stalkers Identified.